everyone, and welcome to LexTalk World Talk Show presented by Clickaway Creators. Today we have Mr. Mareesh Pravir Sahay with us. Mareesh is the founder advocate of Office of MP Sahay, advocate on record Supreme Court, qualified independent director, Ministry of Corporate Affairs, and the member of International Bar Association. There is so much to talk about him, but without any further delay, let me introduce the man himself, and we would hear him out in his own words. Hello, Mr. Sahay. Thank you for joining us. And how are you doing today?
I'm doing well. Thank you for inviting me. And I think it's a great platform and a great opportunity.
Thank you so much. And the platform is going to be even better because when we have people like you on board and talking about the legal fraternity, talking about the latest changes and developments that are happening, I think this adds up a lot of value. So once again, thank you so much for being on the show. Let's quickly get started. And in the first question, this is not really a question, but at the first and foremost, I would like to request you if you can please brief us about yourself and help us understand more about yourself, about your journey so far.
As far as my journey is concerned, I belong to a family where there have been many lawyers in the past, including my own father, who used to practice in the Allahabad High Court and also in the district court at Fatehpur. So yes, I have a direct litigation background. And yes, it helps a lot in the beginning if you are venturing pure into litigation. But I would say that having a background can only help you get certain references or certain clients through certain references, because say your father is also a lawyer or someone else in your family. But ultimately the issue of delivery comes. Unless and until one is competent enough, unless and until one has got the necessary caliber and the skill to deliver results for the client, people may come to you once, but they won't come to you again. So yes, being in litigation background, because this is also a very I can say a hot topic of debate, and it started, I think, since Justice N.V. Ramanna took over as CJI in April, because he has gone on to become the Chief Justice of India, and he's a first generation lawyer. So there were many articles and many discussions on this topic, that being a first generation or a second generation. So yes, first generation is even more tough. It's much more tougher. There's no denying that. But even if you have a litigation background in the family, I would say, as I said, you can have references, you can, know certain people from the outset, but ultimately it's the work or your caliber or your competence or your skill which matters in the end. So I did my graduation from Symbiosis Law School, Pune, passed out in 2009. And since then, for the last 12 years, I've been practicing in Delhi. I also qualified as advocate on record in the Supreme Court. And my main areas and main courts of practice are Supreme Court and National Consumer Forum, National Company Law Tribunal, and Delhi High Court. Although our team covers almost all courts and all tribunals in Delhi, and even we even cater to outstation matters, but these are the primary courts in which our focus is there. So, and Delhi is a place where one would naturally opt for litigation, because not just the Supreme Court is there, almost all the tribunals have their principal seats in Delhi. And the sheer amount of experience and exposure you can have here. You have everything right from district courts to High Court to Supreme Court to all the various tribunals. So yes, Delhi is per se the natural choice. And the going is very tough. Even you may have anything in the beginning or you may not have. Ultimately, litigation is a very treacherous profession, if you may call it. Even a person, say having 30 years of experience, or even a senior advocate having 30-40 years of experience, doesn't know how many matters he's going to have tomorrow or next month. So it is that kind of a profession where throughout, yes, you attain certain levels of stability as you progress, but the amount of certainty always remains. It's very big in the beginning. It's, to a very high degree in the beginning, but it remains to some extent throughout. So it's a very treacherous profession. And I think the only way we can put it is that you have to apply your mind a lot. You have to work hard a lot. You have to have the right contacts and right connections. And I think hard work is the key. Hard work is the key, be it anything. And in litigation, I think besides your competence and skill, sometimes luck also matters a lot. Sometimes you are lucky just to have a good order or good judgment that gives you a great amount of publicity or something like that. So yes, the going has been good by the grace of God, and I just hope it continues in the future as well.
Thank you so much for giving us that quick brief. Adding up onto the same question, can you also help us understand about you being the member of different associations and internationally and nationally? I think it's there in your bio. So if you can let us know about all of them as well.
See, normally when we begin practice, we take the association memberships of the primary court where you are practicing. Like I am a member of the Supreme Court Bar Association and also of the Advocates on Record Association. All the international forums, some are very tough to get as well. I will say it very honestly. The primary objective is that you connect to people working or practicing in those jurisdictions. Like you can say Singapore International Arbitration Center. So it's the hub of international commercial arbitration. So you connect with lawyers working over there, attorneys working over there. You get a chance to work in matters over there, and even say you get to attend many conferences and many seminars. So that gives you a very big opportunity to connect with people who are associated with the work over there. So yes, that's the primary focus of having a good connectivity with people and with lawyers, not just in India but abroad as well.
All right, so thank you so much for giving us that quick brief on that first question and helping us understand about your journey so far. Now let's talk about some complex legal issues that you've worked on. So tell us about maybe one of those complex legal issues that you have worked on. Describe the complexity and tell us how you approached it.
See, every case I would say has some complexity or the other. There's no case you can call a simple case ever, because sometimes we think our case is very good, but we don't get the favorable result from the court. So yes, you can't term any case as an easy case or a non-complicated case. So yes, there are degrees of complexity. I can cite just one case which I remember of the cup, which took place this year only. My client is a very senior person. He's based in Chennai, and there was a family property dispute with his brother. With his brother's son, with his nephew, in fact. And my client had lost in the trial court. He lost in the first appellate court, and he lost the second appeal before the Madras High Court as well. So we had lost in 3 courts. So when he approached me, I told him very honestly that, there are 3 concurrent findings by the courts below against you. So there's not even a 0.1% chance that the Supreme Court is going to entertain. Still, as the remedy is there, he wanted to take a chance. So we took the chance. And as I had told him, the SLP got dismissed. So, once the Supreme Court dismisses the case, there is no further recourse. So you have to, that's the final nail in the coffin, as you can call it. So then I was discussing with him, then it struck me and I suggested him one thing. I said, the Supreme Court has not gone into detail. They have simply dismissed the SLP in limine. And limine is a term in law which says that it's dismissed without any reasoning or without a speaking order or without recording any findings as such. So it was an in limine dismissal. So there are judgments of the Supreme Court which say that if the SLP has been dismissed in limine, that means the doctrine of merger does not apply. That means that the High Court order which was challenged has not merged into the Supreme Court order, whether the Supreme Court upholds it or dismisses it. So I said it's an in limine dismissal. You can still take a chance before the High Court in a review petition. So the High Court will naturally ask you, your SLP is dismissed. So, but the review will be maintainable because the Supreme Court did not go into detail. Because the observation which fell from the Supreme Court is that on law, we may tend to agree with you, but on facts and evidence, there are 3 courts which have held against you, and we are not a fact-finding court, so we are not going to, review the facts or discuss the evidence and the facts again. So I said, you can take this chance before the High Court in a review petition. So my client filed it. I got it drafted and we got it filed through a local council in Chennai. And fortunately, my client got success in that. So here is a situation where, after losing in 3 courts and after losing in Supreme Court, then we go back to the High Court. By some way, we find some route to approach the High Court again, and we ultimately find success in that. So this can be given as one example where you have to, just think out of the box. And as lawyers, obviously, we can't go beyond the law. But I can say that, you can stretch as much as possible within the 4 corners of law. So it's a right, you can stretch it to any limit. and just the primary focus is the interest of your client.
Well, that's great. I think this is also a classic example of reading between the lines. Understanding that there was an opportunity right in front of you, but at times people might miss on that. So that's very important that you read between the lines and make sure that you have to have that line of sight. And I think it's a very classic example. So for our viewers, if you kind of get into such situations ever, or not just similar, but any such situation, make sure that you read between the lines and try to find out the opportunities and the adversities. Thank you so much, Mr. Sahay, for sharing that classic example with us. We'll move on to the next question with that, and let's talk about the pandemic a bit now. So the pandemic saw some courts moving towards more remote proceedings and availability. Do you think this is sustainable and a possible way to increase access to justice?
It's very much sustainable, because see, every calamity which comes, it's a very famous saying, any calamity, any pandemic which comes, it leaves us a lot of opportunities. Had this pandemic not come, though the pandemic is, once in 100 years, it has devastated so much, so many human lives have gone. But at the same time, it gave us many opportunities. It's a very blunt proposition. Had the pandemic not been there, Indian judiciary or Indian legal system would never have even thought of having a virtual court ever. That's the plain truth. So the pandemic comes, and that pandemic, when it started, there was no end in sight. Still, there is no end, although we are hoping it ends finally. So with no end in sight, obviously the judges, the administrators, the decision-making authorities, they had to take a call that, we can't just sit with everything closed for a year, 2 years. We don't know how much time it takes. So it gave us an opportunity. So had it not been there, there would never be any virtual court in India. So that gave us the window. It started in Supreme Court, High Court, sooner like district courts in Delhi, various tribunals, everything followed. Now, yes, it is very advantageous. And Justice D.Y. Chandrachud, who is the judge in the Supreme Court, who is also heading the E-Committee, he'll also take over as the CJI in 2 years' time. So he has been very proactive, and he has also spoken his mind very clearly that, for certain categories of matter, certain types of matter, we can have the system permanently in place. Yes, once the normal situation resumes, like now we are seeing from the last 1 month, we are having physical courts again in Delhi, elsewhere also. But there are certain category of matters which can be kept online. Also because of the reason that, a very large amount of money has been spent in various courts on setting up such infrastructure, all these wide screens in all the courts, a very modern internet connection system, connectivity, staff, dedicated IT team to handle all these things. So you have spent and invested so much. So obviously it has to stay in some capacity. Now, for example, in Supreme Court, when a fresh matter is listed, so there is no other side normally, unless somebody is on a caveat, and it's only you and the judges. So I think this is a fit case where, you can have these cases virtually, or a case in which there are not so many petitioners or respondents, the number of lawyers are restricted, those can continue virtually. Yes, there are cases in which, there would be, say, 30 respondents, 5 petitioners, and, a total battery of 40 lawyers appearing from all the sides. So yes, then it becomes slightly difficult to manage it online. So you can categorize cases even in the district courts. Like if you have it's fixed for cross-examination or recording of evidence, obviously then it's always better you have it physically. But even in district courts and high courts, there are certain category of matters which can always continue to be virtual. It is obviously cost effective, time effective. It has been very productive. I know many colleagues of mine who are like single fathers or single mothers who have small children at home. So this is also a category of lawyers where it has helped them a lot, because even Justice Chandrachud also observed this, that the most, not the most, the biggest beneficiary of the system has been single mothers, or working ladies having small children at home. So this fell from Justice Chandrachud also. So apart from that, there are various other categories of people, of lawyers who have helped, and there are clients who can access if the link is provided to them. So there would be matters where the client is supposed to come from Bombay or Chennai to Supreme Court, and if if we can attend this matter virtually, then you just can imagine the amount of time and cost which is saved in avoiding the travel to Delhi and then coming back. So yes, it should stay in some capacity. It should not be completely washed away just because physical hearings have started. So they can categorize, the judges can apply their minds and, just make a category of cases where some matters can continue virtually and some can continue to be in physical form.
All right, amazing. I think you very nicely thrown lights on all these aspects of having virtual proceedings initiated during the pandemic. But I think if I had to pick up a couple of highlights from this answer, one would be that it is very much productive, it is very much efficient. So this helps the legal industry, the legal community, as well as the clients, both sides. And the second would be when you said that even after pandemic, there should be some category of matters that can continue to be proceeded in the virtual
That's
meetings,
right.
in the virtual
That's
proceedings.
right.
Amazing. Thank you so much on answering that answer and answering that question and probably throwing light on all the possible aspects of it. I'll quickly move on to the next one now. And here, let's talk about about the current legal system drive. So, how would you rate this, the current legal system drive towards encouraging access to justice? Is there a tangible movement in closing the justice gap, do you think?
There is some movement, but I don't think there is any substantive movement in closing the justice gap, so to speak. Nothing visible, nothing tangible as such. It will take a lot more effort, a lot more time, and a lot more, you know, uh, investment, you can call it. Many experts have to pitch in and contribute, judges have to contribute. Uh, Again, Justice Ramanna, the present Chief Justice of India, also spoke about forming a judicial infrastructure commission. He started focusing. I think it's been, I think, the first time any Supreme Court judge or Chief Justice has focused on the infrastructure part and talking about a judicial infrastructure commission. Now, if you see the stats, they are shocking. 31% courts in this country have toilets. Forget having a ladies' toilet separately. So it's a very shambolic state of affairs.
Yeah.
Then there would be hardly 20-30% courtrooms in which in the room only the judge and the lawyers are there. Because I've seen myself in district courts, not in Delhi, elsewhere also, there's a single room, the judge is sitting in one part of the room, the other parts are just barricaded by a temporary structure sort of a thing, and the record keeper, the helmet, the staff is also sitting there. So practically in one room the entire system is operating. So there's no space for lawyers, there's no space for storing the files. So infrastructure is a very big problem. Then I would say the legal services, the legal aid, which is provided by the government and the legal aid authorities to citizens who cannot afford or who are below the poverty line. Like I myself, I am a panel lawyer for Delhi Legal Services Authority, and we get matters for people who are from the downtrodden segment of our society, and we are not supposed to charge anything from them. And obviously, whatever expenses or fees is there, that is reimbursed by us by the to us by the government. But as a matter of fact, I can say I have not even billed whatever is there. I have not even billed my expenses for all these type of matters. So yes, legal aid is there. It is existing in every state, but yes, it can be more effective. It can be made more effective, and more people can be made aware of it, because I think there would be at least 30-40% people from the poor segment of country who would not even know what is a legal aid. Or or I can walk to a district court, and every district court is supposed to have a legal aid center where poor people can go talk to them, and then a lawyer will be provided to them free of cost. So I don't think so 30-40% people would be even aware of it. So that awareness has to be made. So overall, be it judicial infrastructure, access to, because access to justice, I think, is also related to infrastructure. If you don't have the proper infrastructure in courts, it doesn't help anybody's cause. And legal aid, all these things, they have to be worked tremendously. There has to be tremendous work which has to be still, which is to be put into it.
Okay, so as continuing on the same question, Mr. Sahay, as you said that there is a lot of amount of work that's and an effort that still needs to be put in, but you started also suggesting few things that there should be more awareness and infrastructure needs to be improved. Do you have any further suggestions that you think will help us drive this better, particularly in India?
See, I think through the law departments of each state or each union territory, or I think through the bar associations of the high courts. A high court is there for every state in our country. And through bar associations and through the law departments of the government, I think outreach programs can be created, camps can be held, where a team of lawyers or government officials can travel to remote villages you can draw up a schedule, make it more systematic, because it's a very big country to cover. Yes, it will take
Yeah.
time, but if people go there and make people aware, you have legal aid centers everywhere, then I think slowly, gradually things should improve. So I think bar associations, of which we are members as lawyers of various courts, and the law departments of each state or union territory, I think Bar Council of India also, together all these agencies can work towards it.
That's amazing. But this brings me to one more question. I mean, I'm so sorry if I'm just
No, it's
extending
all
on
right.
this one. This brings me to one more question, that there are certain restrictions when it comes to promoting lawyers, promoting law firms. Do you think that can also be one way of spreading a lot of awareness, if lawyers or law firms are allowed to do their
See,
own promotions? Yeah,
that's a very fine line, because unlike America or say many other jurisdictions also, we can't be advertising. Even if we have a website, we have to put in a disclaimer that it's not for soliciting any clients or for advertising purposes. Unlike America, where you are sitting under a bus stop and you would see a hoarding that contact so and so for any injury or accident claims or whatever kind of matters. We don't have that. But I think it's a divided, the opinion can be divided, because, they are very senior lawyers, or, established lawyers or established successful law firms. If advertising kind of is permitted for all, then they would be having more and more of corporate clients or the clients who can pay well, and that would obviously help their business increase. But if you are talking solely with the objective of downtrodden sector or poor section or outreach where people cannot afford lawyers, that would not be so beneficial. Because I say, for example, no law firm or no lawyer would go to a village and put up their hoarding that contact me for any matter, because they know it's a village, nothing's going to come out of it. So I think lawyers can take the initiative, governments can take the initiative. So advertising or is not the solution, I guess.
absolutely right. I think the objective here is to make justice reach to people, or it making easier for people to reach for justice or
That's
ask for
right.
justice, not really making it a money making business. Absolutely
That's
right.
right.
I agree with you. Thank you so much for answering all those follow-up questions as well. I'd like to quickly move on to the next one now. And here, let's talk about the legal technology a little bit. So we are in the era of legal technology. What are the most commonly used tools for you, Mr. Sahay?
Besides the conventional internet based or pen drive based or those types of systems where we look for judgments and research for precedents, etc., in the last few years there's a very big boon of these case management mobile applications. You can access them on the app through your mobile or even on the website also. So case management thing, what comes is that I log in, I am a subscriber, so I get access. Then whatever X number of cases my office or my chambers are handling, I put in all those details in that application. Now, the convenience which comes is, and the good part is, suppose my matter is listed in Supreme Court, tomorrow is my hearing, I have to look for the last order. So normally I would go to the Supreme Court website, if it's a Supreme Court matter, look for the last orders and everything. Now here in this case management application, what happens is there's a list of 100 matters. It may be, say some matters are Supreme Court, some are Delhi High Court, some may be of different tribunals or even the lower courts. You just click on that matter. All the various orders are provided there and then. It doesn't connect to some external website or something. It's there, right there in front of you. Then there are connected features like there's a billing option where you can keep your bills, you can keep your invoices which you send to your client. Then there is a diary kind of a system where you can record the minutes, which is useful in billing and raising invoice or memos to our clients. Then there's a inbuilt mechanism for researching judgments also. And then there's a cloud service also now, where all the connected documents or pleadings, the scanned copies are right there. So, you just open the application, there's a huge list of your matters. Just click on any matter, right from the court information to any internal office document, everything is available in one place. So I think that's a very good innovation which has happened, and it's on the rise.
Yes, I'm sure, and I've heard a lot of other legal professionals also making the use of these different case management apps, and they have been appreciating this effort in the past couple of years that we have seen. I'd like to quickly move on to the last question. We are taking off time now. So the last question talks about time is money in any profession, and in legal it's most of all. How do you ensure to make the best out of your time as a lawyer?
Yes, it's not all the important or something which.
Okay, amazing. All right, thank you so much for sharing those great insights with us, Mr. Sahay. With that, we come to the end of this session. I'd like to thank you once again for your time and sharing all those answers and sharing all those great insights with us. I'm sure our viewers must be making notes out of this and learning a lot of new strategies and innovations that they can put into their practice as well. So for our viewers, if you like this chat with Mr. Mareesh Pravir Sahay, please like and share this video with your colleagues, with your family members within your network. Also subscribe to our channel, Clickaway Creators, to have more coming from the industry leaders like Mr. Sahay. Mr. Sahay, thank you so much for your time once again. We would like to have a chat with you once again in the future on some other trending topics in the legal fraternity. For now, this is Vinay signing off for LexTalk World.